warm greetings to one and all present here. It's been after a long that we are meeting on this platform for one more interesting lecture. I, Dr. Shikha Dhaman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be enlightening you all on the topic Independence of Judiciary. Let's begin with the introduction. The principle of independence of judiciary ensures that the courts and judges operate free from external pressures and influences. In India, we follow separation of powers, which divides the mechanism of governance into three branches, that is legislature, executive and judiciary, and the three have distinct functions to perform. The chief function of the legislature is to make laws, the executive implement the laws which is made by the legislature, and the judiciary is that branch of the government that interprets the law, settles the disputes and administers justice to all the citizens. Although the functions of these organs are interconnected, as the laws made by the legislature will be implemented by the executive and will be further interpreted by the judiciary, but it is necessary that one government must not interfere or intervene in the functioning of any other government. The functions of these institutions must remain independent from one another to achieve the purpose of separation of powers, which is to prevent abuse of power by a single person or group of individuals. It will protect the society from the abuse of power of the state, safeguard freedom for all and allocate each function to the suitable organs of the state for effective discharge of their respective duties. Among these three organs, independence of judiciary is of paramount importance, as judiciary keeps checks and balances upon the legality and constitutionality of the functions performed by the legislative and the executive in the form of judicial review. Judiciary has the power to invalidate any law, ordinance, order, bylaw, rule, regulation, notification, custom or the usages that has the force of law and is incompatible with the provisions of the Indian Constitution. When the judiciary is independent, it can make impartial decisions based solely on legal merits without fear of retaliation or bias from other branches of government or external forces. This independence of judiciary will not only ensures the fair administration of justice, but also enhances the trust and confidence in the mind of masses for the judicial system. The independence of judiciary is a cornerstone of democratic governance, ensuring an impartial and fair legal system. Judicial independence serves as a safeguard against the abuse of power, enabling the judiciary to serve as a check on the legislative and executive branches. This independence is not limited to the decision-making process of judges, but also encompasses their appointment, tenure, remuneration and conditions of service, which should be insulated from political interference. Now, let us discuss the meaning of judicial independence. The independence of judiciary refers to the principle that the judicial system operates free from interference, influence or pressure from the other branches of the government or from any private or partisan interests. In other words, it means that the judiciary should not be restrained by other organs of the government, allowing the judges to perform their functions without fear or favor, ensuring that judicial proceedings are conducted fairly and that the rights of parties are respected. However, independence of judiciary does not imply arbitrariness or absence of accountability. Judiciary is a part of the democratic political structure of the country. It is therefore accountable to the Constitution to the democratic traditions, and eventually to the people of the country, as according to the Constitution of the India, it is the people of India with whom ultimately the sovereignty lies. Now, let us discuss the types of judicial independence. There are mainly two types of judicial independence. They are institutional or functional independence, and second is decisional independence. Let us talk about the first one, that is institutional or functional independence. Institutional independence means that as an institution, judiciary has the power to function on its own without any kind of interference or intervention from the other two organs. It is mainly based on the separation of powers. The judiciary has the supreme authority in deciding the appointment, transfer of judges, and salaries and amenities to be provided to judicial officers. Second is decisional independence. Decisional independence means the absence of any biasness or partiality while deciding a particular case. The judges should be independent and impartial and must decide a case based on the facts and law, and most importantly, judges should follow the principles of natural justice. Now, let us give a highlight on the historical background of judicial independence. Independence of judiciary is based on the doctrine of separation of powers, which was coined by the 18th century French philosopher Montesquieu. However, as a concept, the independence of judiciary was first adopted by England in the Act of Settlement 1701. For the first time, this statute provided for a secured tenure of the judges and a formal mechanism for their impeachment, as a result of which judges could no longer be removed upon the will of the Lords. Prior to the enactment of Act of Settlement 1701, judges could be removed from their position through the Crown just like other civil servants. Moreover, judges had to decide any matter in the favour of the King and Queen. In case they failed, the royal family had the power to remove those judges. After the enactment of the Settlement Act of 1701, to impeach a judge from the position, the assent of both Parliament houses is needed along with the Queen's official address. Makers of the Constitution of United States were also inspired from the Act of Settlement, and they consequently inserted Article 3 in the US Constitution, which serves as a base of American judicial independence. Now, the question is, what is the need of judicial independence? Constitution of India provides certain basic rights to the citizens of India which are necessary to live a dignified life in a form of fundamental rights. It is the judiciary to which people come in case of violation of the fundamental rights and they seek relief. Being the guardian of the Constitution, it is paramount important that the judiciary remains independent and freely protects and upholds the right of individuals. Judicial independence is essential for maintaining the rule of law and upholding democracy in any society. It ensures the judges are free from external pressure, including the political influences or any threats from powerful entities, and can make, of course, the impartial decisions. This independence fosters the public confidence in the legal system, as individuals believe they will receive fair treatment regardless of their status or connections. Moreover, an independent judiciary serves as a critical check on the government power, safeguarding the individual rights and preventing the abuses. By allowing the judges to interpret and apply the law without any interference, judicial independence upholds the foundational principles of justice, fairness, accountability, and ultimately contributing to just and equitable society. Now we have some of the constitutional provisions that deals with the independence of judiciary. Those are, first is regarding the appointment. As per clause 2 of article 124, it is the President who appoints the judges of the Supreme Court. However, his discretion in this matter is restricted in the same sense that he is required to hold the consultation with the judges of Supreme Court and of the High Courts while making the appointment of judges. Proviso to clause 2 of article 124 requires that the President must consult with the Chief Justice of India in case of appointment of judges other than the Chief Justice. The position is more or less same in the case of appointment of High Court judges. According to clause 1 of article 217, the President shall consult with the Chief Justice of India, the Governor of the state, and in case of appointing the judge other than the Chief Justice of that concerned High Court. The body that recommends the names of judges to be appointed to the President is known as collegium. Collegium is nowhere mentioned in the Constitution, but it is mainly developed through the judicial pronouncements. This collegium system for appointing the Supreme Court judges is made up of 5 judges, including the Chief Justice of the India and the 4 most senior judges of the Supreme Court. Once the candidates are chosen, their names are submitted to the President and the government for their approval. The government may raise objections and request some clarifications. However, if the collegium resubmits the name, the government is obligated to appoint them. The collegium responsible for selecting the High Court judges consists of the 3 members, the Chief Justice of the High Court and 2 of its senior most judges. After the selection, the names are forwarded to the state government for the review. The state government conducts the background inquiries on the candidates and then sends the names to the central government. The central government in turn submit these names to the Supreme Court Collegium, which also comprises again 3 members, the Chief Justice of India and the 2 senior Supreme Court judges. Now, if the central government requests the reconsideration, the collegium resubmit the same names, the government must appoint those candidates. Another provision for the independence of judiciary is security of tenure. The judges of the Supreme Court and the High Courts have security of tenure. Once appointed, they continue to be in the office until they reach their retirement age. As per Article 124 Clause 2, the retirement age for a Supreme Court judge is 65 and for a High Court judge it is 62 as per Article 217 of the Indian Constitution. The judges can be impeached from their position if misbehavior and incapacity are found on their part. The President of India can only impeach a judge on the recommendation of both the House of Parliament. Now we have the salaries and allowances. Article 125 of the Indian Constitution talks about the salaries of judges. Judges have a fixed salary rate. This is also the reason for which judges can work independently. Supreme Court judges get their salary from the Consolidated Fund of India and High Court judges, they get their salaries from Consolidated Fund of the state. Except in the cases of financial emergencies, salaries and allowances of judges cannot be altered. Another provision is the powers and jurisdiction of the Supreme Court. As per Article 32, an individual can directly go to the Supreme Court in the case of infringement of any of their fundamental rights. Supreme Court, as the guardian of law and for the protection of fundamental rights of citizens, is empowered to issue writs. Parliament has the authority to authorize the Supreme Courts to issue directions, orders, writs, or for purposes beyond those specified in clause 2 of Article 32. This means that the Parliament can expand the powers and jurisdiction of the Supreme Court, but cannot limit it. No discussion of the conduct of judges in the Parliament or state legislature. We have another feature of independence of judiciary, that according to Article 121, there shall be not any discussion in the Parliament regarding the conduct of any judge of the Supreme Court or of the High Court in performing their duties, except when there is a motion regarding the removal of that judge. Article 211 puts the same restriction in case of the state legislature without any exception. Another feature is contempt of court. Under Article 129, the Supreme Court has the power to punish for its contempt, and similarly under Article 215, it empowers the High Court to punish for the contempt of itself. Another, we have separation of executive from the judiciary, or we can say separation of judiciary from the executive. The Constitution establishing the independence of judiciary is mentioned in Article 50, one of the directive principles of state policy. This article says that the state shall endeavour to separate the judiciary from the executive. Judiciary should be separated and free from the control of executive. Now we have some established case laws on the independence of judiciary in India. A very first and landmark case is S.P. Gupta versus Union of India of the year 1982. This case is also known as first judge's case. In this judgment, it was held that the word consultation did not include concurrence, and further that the power of appointment of judges under Article 124 was vested with the President, and the President could override the views of judiciary. It was also held that the CGI's recommendation regarding the appointments and transfer of judges could be refused for some cogent reasons. In this case, the Supreme Court reduced its power to appoint the judges and gave the entire control to executive. However, then came the transition in the another case, that is SC Advocates, or I would say Supreme Court Advocates on Record Association versus Union of India of the year 1993. This case is known as second judge's case. In this judgment, the Supreme Court introduced the collegium system, holding that the consultation really meant concurrence. It was also held that it was not the CGI's individual opinion, but an institutional opinion formed in consultation with the two senior-most judges of the Supreme Court. After that, we had third judge's case. That was a reference case of the Presidential Reference 1999. This case, as known as the third judge's case, where the Supreme Court upheld the previous judgment. It was held that without proper consultation with other judges, the Chief Justice of India's opinion is not obligatory on the executive. Moreover, the strength of collegium was also increased to 5 members, with the Chief Justice at the head and 4 other senior-most judges. And finally, we had the 2015 case, that is Supreme Court Advocates on Record Association and another versus Union of India. It is also known as the fourth judge's case. In this case, the Supreme Court declared unconstitutional the 99th Amendment Act of 2014, which proposes to establish a National Judicial Appointments Commission to replace the existing collegium system for the appointment of judges in the High Court and Supreme Court. The members of the commission would be Chief Justice of India, 2 senior-most judges of the Supreme Court, the Union Minister of Law and Justice, and 2 eminent personalities who shall be selected by a committee comprised of the Chief Justice, Prime Minister, and the Leader of Opposition. Now let's have a view on the international perspective. Article 14 of the International Covenant on Civil and Political Rights (ICCPR) serves as a fundamental legal basis in international law for defining judicial independence. It asserts that everyone is equal before the courts and is entitled to fair and public hearing by a competent, independent and impartial tribunal. The United Nations Human Rights Committee elaborates on this article in a general comment number 32, which outlines a working definition of the judicial independence consisting of several key principles. Number 1, courts must treat all parties without discrimination. Number 2, courts must be free from bias or favoritism towards any party. Number 3, courts should not prejudge a case. Number 4, courts must maintain political independence, avoiding dependence on or influence from the executive, administrative or legislative branches of government, which could also be parties in cases before them. Fifth, courts must be able to perform their duties without concern for repercussions, ensuring they are not pressured or retaliated against for unfavorable judgments. Now, these principles help fulfill the dual role of judicial independence in a constitutional democracy. Number 1 is safeguarding the human rights as well as ensuring the rule of law. The United Nations Basic Principles on the Independence of Judiciary brings these aspects together in a clear definition, which states, the judiciary shall decide matters before them impartially on the basis of facts and in accordance with the law, without any restrictions, improper influences, inducements, pressures, threats or interference, direct or indirect, from any quarter or for any reason. Many constitutional democracies have incorporated the aspects of this definition into their domestic laws, such as South African Constitution. We have Article 165 Clause 2, which states that the courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favour or prejudice. Another, we have the Kenyan Constitution, Article 160, which states, in the exercise of judicial authority, the judiciary shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. Then we have 2012 Egyptian Constitution, Article 74, which recognized these requirements in principle. The provision is identical to Article 65 of the 1971 Egyptian Constitution, which states, the independence and immunity of judiciary are two basic guarantees to safeguard the rights and freedoms. In Tunisia, the June 2013 draft constitution provides under Article 100, 101 and 106 that the judiciary is an independent authority which ensures the prevalence of justice, the supremacy of the constitution, the sovereignty of law and the protection of rights and freedoms. Judges are independent. No power shall be exercised over their rulings other than the power of the constitution and the law. A judge must be competent. He must commit to impartiality and integrity. He shall be held accountable for any shortcomings in the performance of his duties. Apart from this, now we have some challenges to be discussed with respect to judicial independence. Independence of judiciary is one of the many destinations at which a constitutional democracy aspires to reach. However, there are certain obstacles which come down to the road towards judicial independence and which are necessary to overcome, such as biases. Judges are expected to be impartial and free from the biasness while passing any verdict. The maxim, nemo judex in causa sua, stems from this principle, which means no one should judge their own cause. However, there are certain types of biases which are faced by the judges while deciding a case, such as personal bias when any party is related to the judge, or pecuniary bias when the judge has any kind of monetary interest in the subject matter of the dispute. Another challenge is the corruption. Judicial corruption compromises the integrity, fairness and impartiality of the judicial system. It undermines the public confidence in the legal system and can severely affect the administration of justice. Judicial corruption can take various forms such as bribery, favoritism, collusion and many more. Another challenge is political influence. Political parties frequently attempt to influence the Indian judiciary for their own personal and political gains. Members of these parties often interfere to obstruct the judiciary's operations when their interests are not being met. Another one more challenge is security issues. It is quite common for the judges to receive threats due to their commitment to fulfilling their judicial responsibilities. Judges frequently encounter life-threatening situations simply for performing their judicial duties. There have been numerous cases in which judges have been killed in broad daylight for delivering the unfavorable rulings. Then we have one more challenge, that is interference from legislative and executive. Although India adheres to the doctrine of separation of powers, the other two branches of the government frequently attempt to encroach upon and restrict the judicial authority. There are instances of functional overlapping among these branches which can hinder the judiciary's ability to operate impartially. Now, these were all the challenges, and now we are heading towards the conclusion. In conclusion, it can be very well stated that the independence of judiciary is necessary for the functioning of a fair and just society. It acts as an important safeguard against the abuse of power and ensures the supremacy of rule of law, which further protects the rights of individuals. An independent judiciary not only enhances the public trust in the legal system, but also upholds the principle of democracy and rule of law. As societies evolve and face new challenges, the protection of judicial independence remains paramount. Continuous efforts to uphold this independence are vital, as political pressures and attempts at influence threatens their integrity. Even if there are certain shortcomings in the existing judicial system, it still acts as a last resort for the common people to seek justice owing to their confidence in the judiciary. This confidence of the public in the judiciary must be preserved at all the costs, and this can be done only by upholding the independence of judiciary. Thank you everyone for your valuable time and attention. I also appreciate the opportunity to speak and share my views with you today. Thanks once again. Take care. God bless you.